Hello everyone, this is Tom Fox and I'd like to welcome you to episode 280 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps clients manage risk across 4 key risk areas. These risk areas include sales and sales channels, including distributors, resellers, and partners, suppliers, customers, and human capital. Human capital consisting of employees and contractors. You can find out more information at the Red Flag Group's website, which is found at www.redflaggroup.com. If you're attending the SCCE Compliance and Ethics Institute in Chicago, I hope you will drop by the Red Flag Group booth and say hello and check out some of the incredible new technological products and services that the Red Flag Group is offering. I'll be there and I hope to see you there and at the SCCE 2016 Compliance and Ethics Institute. Today I have with me Rich Gargenti and Tim Headley. They are both with KPMG and they have written a very useful new book entitled The New Era of Regulatory Enforcement, a comprehensive guide for raising the bar to manage risk. In this book, they take a look at a wide variety of risk areas, including bribery and corruption, money laundering, economic trade and sanction, market manipulation, insider trading, financial reporting fraud, unfair deceptive trade practices, offshore tax evasion, fraud and misconduct in healthcare, and fraud and misconduct in the life sciences. But I visit with them about their outlines of a framework for managing risk. Their outlines, I found, work across multiple types of risks, and they work for really any type of compliance program. The episode comes in at 25 minutes or so. I think you will find it quite interesting. I'm going to link to the book in the show notes. And also the individuals gave their email addresses if you want to follow up with them directly. This is Tom Fox, and I'd like to thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox, and I'd like to welcome you to this episode of the FCPA Compliance Report. Today, you are in for a real treat because I have Rich I hope I get this right, Gargenti and Tim Headley. They are both with KPMG, and they have written a new book entitled The New Era of Regulatory Enforcement, a comprehensive guide for raising the bar to manage risk. Gentlemen, welcome to the podcast.
Thank you. Glad to be here, Tom.
So this book, I read this book over the past week, and it is just an excellent guide to a wide variety of regulatory enforcement and risks. As you know, I'm in the anti-corruption risk business, but it's much broader than that. So could I ask you guys, what led you to write this book?
Well, let me begin that, and obviously Tim can add to it. I think this past week with the bombings in New York City and New Jersey, and with the celebration or the commemoration of the 9/11 attack 15 years ago, what we've seen over the past 15 years, beginning with 9/11, have been a series of landmark events that have led to a dizzying array of new laws and regulations. And in the case of 9/11, we saw the U.S. Patriot Act and the war on terrorist financing that followed that. A lot of the anti-money laundering regulations and enforcement began after 9/11. So in addition to the speed and volume of these new laws and regulation, we've also had the phenomenon of increased globalization, emerging nations, proliferation of digital data, and we've also seen more aggressive enforcement, new tactics, and more global in nature. And all of this led Tim and I to say that there's so much that has happened over the last 15 years that we'd like to help our clients and others who are in the risk management business to connect the dots, to begin to understand what has happened and what companies, our clients in particular, need to do in order to meet the challenges and to manage the risk that this new era has created. We wanted to provide a more detailed framework that could be applied. There's a lot of different types of guidance that's out there, from the sentencing guidelines to what the different agencies have put out. We wanted to create a framework that would help companies understand what they need to do, what are the various tasks and activities that they need to perform in order to be able to manage not only the risks that have emerged during the last 15 years through the series of events that have occurred, but also to manage specific risks that might emerge in the future, and having that kind of compliance framework available to them and explaining how it might be applied in general and also to specific risks, whether it's anti-bribery and corruption or anti-money laundering, we thought was an important value that we could provide to the readers. I mentioned 9/11 as being kind of a seminal event, but there have been others that have occurred over the last 15 years that have also changed the landscape. Certainly right on the heels of 9/11, we saw the financial reporting crisis, the Enron situation, and what occurred after that is we saw Sarbanes-Oxley pass, which obviously put in a new regime of governance for boards and C-suite executives. With that came additional enforcement. We saw in 2004, 2005, and you've chronicled this quite in detail, a renewed effort around anti-bribery and corruption, which I think had a lot to do with the increased globalization and the emergence of developing countries, in particular the BRIC countries, where many companies were now doing business and created new risks. In 2008, 2009, we saw a financial recession, which was the deepest recession that we had experienced since the Great Depression. And with that came the Dodd-Frank legislation and other relief measures that also created new laws and regulations, new enforcement powers for agencies such as the SEC and the Commodities Future Trade Commission, the creation of new agencies that had enforcement powers like the Consumer Financial Protection Bureau. And all during this period of time, we've seen fines and penalties that companies have paid increase dramatically, where at one time they were tens of millions of dollars. Today we're seeing tens of billions of dollars in fines and penalties. All of this is a long way of saying that we felt the need to put on paper something that people could read and a guide that they could go to begin to help them manage what is occurring in this new era.
Yeah, and Tom, I think Rich did an excellent job of explaining why we wrote the book, but one thing I think I would add to it, the book represents the conversations that we've been having with our clients over the last few years. And we thought it was an opportunity to put all of this thinking and thinking the part of our thinking, part of the KPMG, part of our clients in one place, be able to share with a much broader audience.
So Tim, Rich and I are both lawyers, and you are a certified public accountant and a certified fraud examiner. So from that perspective, could you start off and tell us why managing risk is so critical for the corporation today, as opposed to managing sales or managing some other aspect of corporate governance or life?
Yeah, I think my perspective is a little bit different because I'm an accountant by training. I've been doing compliance and forensic accounting work for about 20 years. Managing risk is actually, these are the things that threaten the existence and the viability of an organization. I think that the compliance landscape has changed significantly over the last few years, and the risks are that much greater. As an accountant, you think in terms of controls. We think about preventing misconduct. We think about detecting misconduct and responding to it. So I think it's vital that an organization have some sort of mechanism and think proactively about mitigating these risks if they want to maintain their economic viability in this market.
I think it was interesting that both Tim and I, while we've worked together for many years now, have different backgrounds and perspectives, and I think we've tried to put those two backgrounds and perspectives together. When I look at it from more of a lawyer's perspective, I see that there are innumerable laws, regulations, and rules out there, and companies are struggling to understand and comply with them. And we also see that those who are willing to invest in effective risk management and compliance can sometimes avoid the consequences of fines and penalties. They can, at the very least, mitigate the harm of the inevitable misconduct or breaches that will occur within an organization. So lawyers who are representing clients who have issues can you take advantage of an effective compliance program, a strong culture of integrity, to be able to argue for leniency. And the government has shown recently that they're willing to listen to those arguments. And they have compliance counsel, as you know, in the Department of Justice, who's evaluating the effectiveness of compliance programs. So from a legal perspective, there's a lot to be gained from taking the time and effort to invest in effective compliance.
Yeah, and it's juxtaposed with that whole notion of economic viability. So I think that combination of our backgrounds and skills have done well in moving forward our messaging.
So I've often heard the phrase, the 3 lines of defense. Could you all explain what that is, or at least how it relates to compliance?
Sure. This is Tim. I'll start, and Rich, of course, jump in where you think appropriate. In essence, the 3rd line defense illustrates how the key parts of an organization, whether it be the board of directors, to management, which in operations would represent the 1st line of defense, to the compliance function, which constitutes the 2nd line of defense, and the role of internal audit, which is the 3rd line of defense, how they all work together to support, in essence, a culture of integrity. The 1st line of defense, management operations, they identify risks and put in place policies, programs, and controls to mitigate those risks. The 2nd line of defense, the compliance function, designs and implements the compliance function itself. They advise management and the board. And importantly, they monitor the overall effectiveness of an organization's compliance efforts. The 3rd line, internal audit, provides a certain level of assurance as to the effectiveness of all of these compliance efforts. So the idea is that it's a construct that looks at all these major components of an organization, how they work together to support compliance.
I mean, to simply state it, compliance is not and should not be viewed as a standalone function within an organization. All parts of the organization, whether it's part of the operations or part of the strategy of an organization, need to be involved along with compliance and risk management to ensure that a company has the best organization it can to be able to effectively deal with issues of integrity within their organization.
You guys lay out several of the different roles for the corporations, or disciplines within a corporation around compliance. But I'd like to specifically ask you, what's the role of governance in risk management?
Well, governance is what ties it all together. It ensures that there is a functioning infrastructure within the organization that supports accountabilities and provides for proper oversight. Without accountability and without independent and objective oversight, you can't have an effective compliance program, and all of that begins with government. Governance supports the proper functioning of the 3 lines of defense that Tim laid out, and ensures that those lines of defense are coordinated, working together, that internal audit, whether it's compliance or whether it's management, are talking to each other, that they're leveraging the systems that they have in order to perform their responsibilities. It ensures that risk and compliance function are properly resourced. One of the things that governance helps determine is what are the resources, what are the tools that the compliance function needs to have, and an effective governance structure will certainly support with proper resources and proper tools the compliance function.
I think Rich laid out a lot of all the building blocks of it. If I had to sum it up in kind of one thought, it would be it's the keystone to make all these building blocks actually fit together with respect to compliance.
So it's really more just tone. It's actually not only talking the talk, but walking the walk.
Yes, it's more than just tone. We talk a lot about tone at the top, what have you, and that's an integral part of it. But I think if you look at some of the classic failures in history, on paper the tone looked right, but the people didn't actually walk the talk, so to speak, and that messaging was not believable. Governance is all about making that messaging believable.
Yeah, I spend a lot of time to chief compliance officers in major companies around the country and globally as well. And this is one of their important discussion topics. You know, what is my response vis-a-vis the board? How do I make sure that the board the right information so it can perform its function of oversight. How do I relate as a compliance officer to management? What assistance and advice do I need to provide them? In determining the effectiveness of a compliance program, how do I work with internal audit? All of those questions are addressed if the governance structure of a company is working as it should. And that's why it's not just simply a tone, it's really how the parts connect and who has responsibility and accountability for those parts.
Well, Tim, you'll probably appreciate this. A couple of years ago, as I mentioned, I'm a lawyer, and a couple of years ago, I discovered something called COSO. And when I read COSO, I thought, gosh, these are compliance controls. This has nothing to do with financial controls. And I was explaining my revelation to a friend of mine at PwC, and he said, if you're a lawyer and you can spell COSO, you go to the front of the line. That's a long-winded way of introducing, one, my former ignorance, and two, my revelation as to why controls are the absolute backbone of any compliance program. And you've got some really interesting thoughts on here about not only the three types of controls, prevent, detect, and remediate, but could you explain the difference between detective controls as opposed to preventive controls and what the roles of detective controls are in an effective compliance program?
Sure, I'd be happy to do that. Any effective compliance risk management process is going to encompass controls that have essentially three objectives. The first, prevent instances of misconduct from occurring in the first place. Second, detect instances of misconduct when they do occur. And unfortunately, no matter how good your compliance efforts are, some things can go and do go wrong. And then I would call it, I guess, a third pillar of it, respond appropriately and take corrective actions when breakdowns occur. Your preventative controls include, I believe, first and foremost, risk assessments, understanding what the risk landscape looks like. Preventive controls also include codes of conduct and related standards, and these are hugely important, and I think some don't find how important they are, because this is where people learn to apply the right values to decision making, and is at the point of decision where integrity breakdowns take place. That includes employing third-party due diligence. And John, from your other podcasts, I know that's been an important component of those podcasts and discussions. Includes organization-wide communications and training, not just some of the things I've heard on your other podcasts. It also includes process-level controls, because the things we've been talking about so far have been sent at the entity level, or process level, are really down to where it's transactional level type controls, another way of putting it. Detective controls include your hotlines and other whistleblower mechanisms. Includes auditing and monitoring of compliance efforts and actual compliance with policies, programs, and controls. In the environment we're in now, another thing that we tried to address fairly deeply in the book was the notion of proactive data analytics and the use of analysis of big data. Most importantly, in preventative, it is important that individual stakeholders, all stakeholders, understand this process, their affirmative obligation to report wrongdoing. We talked earlier about the three lines of defense, but in some sense, and I'm doing this for over 20 years now, and Rich even longer, truly your first line of defense are your own employees and stakeholders, and most of my investigations over those years have actually been derived from employee tips. Finally, you have the response protocol, or response controls, which are used in the form of protocols. You'll have investigative protocols. These will be protocols that are almost a schematic for how to think about investigations. I don't like to make those too prescriptive, but there's certain things that every organization should think about when they are conducting an investigation, like triaging it, who will do the investigation, the resources, and things like that. Do we need to bring in other people into the process? Includes enforcement and accountability protocols. Rich had mentioned earlier holding people accountable with respect to appropriate governance. Also enforcement protocols. I have to make sure that people are disciplined consistently and fairly and appropriately. I would need, as part of response, disclosure protocols. And this is not just disclosure that you would find in your annual financial report and the notes, about whether or not I should think about disclosing potential misconduct to government regulatory bodies. And then finally, and maybe most importantly, remediation protocols. Many of my clients, unfortunately, don't give a whole lot of thought to these, but the idea is I have to remedy the harm caused, and I have to think about if there were control breakdowns. I have to have a feedback loop that says, hey, I need to fix the internal control infrastructure to make sure I don't have these problems in the future. So essentially, Tom, that encompasses that world of prevention, detection, and response controls that you had been referring to.
Well, I think Tim outlined it as well as it can be, but I'd like to not add to it, but just point out two things that I think are really critical and that run across all of these, whether it's prevention, detection, and response. One is the importance of technology and data analytics as essential tools, whether it's prevention, detection, or response. Organizations have seen proliferation of their digital data. They've seen significant transition to digital content and records. Their core systems in many instances are outdated, and they need to be able to use the tools that are available today, all the way up from looking at things that may have occurred in the past, which is sort of the traditional way to do things, to artificial intelligence, machine learning, cognitive learning, whatever you want to call it, where they can begin to predict the things that might go wrong within an organization. So there's a lot of work being done, whether it's prevention, detection, and response, to improve the technology and data analytics around risk management and compliance. And let me just put a final emphasis on the point around culture. There's a lot of talk about culture. It's kind of that soft thing that's out there. But the regulators are starting to look at culture with a much more specific eye. We've seen with FINRA, for example, that they've set out a standard of what a culture means and is defined. Organizations are starting to benchmark themselves, whether through interviews, whether it's workshops, whether it's through surveys, to begin to assess their own culture and benchmark it against their past and benchmark it against others in the industry. More and more, the regulators are looking at what the culture of integrity is within an organization. That's whether they've gotten it right. Because even with all the controls in the world, all the proper controls, if the culture of an organization isn't what it should be, then that organization is going to be at higher risk than one that has a good culture. And then I guess finally what I'd like to say is that this is, to me, more of an investment in not only high performance, but high integrity, but also high performance. I think too often companies look at the compliance function as a cost, when in fact it is a cost, but it's also an investment, and it can improve not only the integrity of the organization, but its performance as well.
You know, I'm really glad you said that. One of the things that struck me, or stuck with me rather, over the years is I heard John Reed, formerly of Citigroup, say something along the lines of the following: the reason you have brakes on a car is not to slow down. The reason you have brakes on a car is to go fast. And I tell business types that that's the reason you have an effective compliance program, because it allows you, as you said, to have a high performance organization. So I really appreciate those comments. Rich, let me ask, at least start off with this one with you. You touched on the government and what I'd call the FCPA pilot program, where they're giving credit for having compliance programs in place. But one of the elements is also doing remediation during the pendency of an investigation, certainly in my FCPA world. You all talk about a remediation protocol, and I don't think that's something that really has gotten as much play as some of the other protocols. So could you explain what that is and how a compliance officer or legal department or a company could use a remediation protocol?
Yeah, I think this has been a little bit more of the currency of today, where not only are the agencies like the Department of Justice and SEC looking at internal controls, but they're looking, even during the pendency of an investigation, for what the company is doing to identify the problem or the breakdown that occurred that led to whatever misconduct. And it's, it could be as you and I have just talked about, something in the area of an FCPA violation, but also other forms of misconduct. We've seen it whether it's the LIBOR investigation or other investigations of misconduct within an organization. The government wants to know that you've identified the problem, that you've cooperated with the government. They also want to know that you're prepared to disclose, and they also want to know that you are taking measures to fix the problem. Many of these investigations on the part of the government take years, and they want to know that the compliance function is looking not only at the internal controls, but any weaknesses in the compliance program, whether it's weaknesses as a result of lack of resources, whether it's weaknesses because their risks assessments have not addressed the issues that really have created the problem. Whatever it is, they want to know that remediation efforts are going on, and those remediation efforts will be tested for their effectiveness, and that puts a company in a much better position when there's an enforcement action to be able to argue for and ultimately get some level of leniency where the misconduct has occurred.
Yeah, I agree with that. With respect to response, I think the expectation today is that the remediation is going to be real time, rather than wait until all the dust clears and you understand everything that took place as you move along through that investigative process that Rich was mentioning, that you are performing the remediation in real time and not waiting until completely after the fact. You understand all the facts and circumstances, move completely through the disposition of the investigation, but during that process, you are remediating.
Well, with the certainly in the FCPA world, with the pilot program, they have made clear that extensive remediation is one of the key factors that the DOJ will look at in terms of giving a reduction of a fine penalty or even a declination. So it's something that companies really need to think through, having it in place, both, as you said, Tim, the remediation controls, but also, as you talked about, Rich, the remediation protocol. So, gentlemen, unfortunately, we're near the end of our time, but I was wondering if any of our listeners wanted to reach out to you, could they do so? And if so, could they email you, and how would they do it?
The best way would be through email. My email address is pretty simple. It's rgirgenti, Girgenti at kpmg.com, and I will do my best to respond in a very timely fashion if there are any inquiries. Tim?
And no, same for me. Email is always best. And the email is thedley, Thedley, also at kpmg.com.
And Rich and Tim are the authors of The New Era of Regulatory Enforcement, a comprehensive guide for raising the bar to manage risk. And as I said, I will link to this book in the show notes. I heartily recommend it. It would be a great addition for a general counsel, a compliance officer, a compliance practitioner, or anyone else who wants to understand not only the specific regulatory enforcements that we are facing in business today, but a way to think through or put a framework in place. So, gentlemen, I'd like to thank you very much for taking the time to visit with me today.
Thank you, Tom. Appreciate the opportunity to talk to you.